Good morning once again. This is Keith Taylor. I am the inventor of the turn signal mirror. Maybe you've perhaps seen my other videos on YouTube. There's two that I created prior and one with Fox News. I invented the turn signal mirror that you see on various cars, starting out with Mercedes-Benz and going on to over 40 other brands of cars. I haven't been compensated for this patent. If you'd like to view the other videos to bring you up to speed, I'll give a brief review here, but go to Keith Taylor Mirror on Google and 3 will come up. The first one will be with Fox News and 2 others that I made on my own. This morning, we're going to give a brief introduction or review of where we came from. I worked with Chrysler before they were Daimler Chrysler. Back when they were in Highland Park, Chrysler has been involved in this from the very beginning. Even when the patent was pending, I was working with high officials at the Chrysler plant. Mr. John Hurlitz was the senior vice president. I worked with chiefs of design, crash avoidance, new products. I worked with Chrysler all the way through. They were even involved in helping me get a license agreement with the manufacturer. When that went sour, they sent me to another manufacturer. They were even involved all the way up after the suit was lost, and someone from Chrysler was involved with me retaining a malpractice attorney. We'll get to that a little later. While I was working with Chrysler, I licensed the mirror to Chrysler Globe, a company that I was sent to by Mr. Hurlitz. We had this patent all over the world, in the United States, Canada, all throughout Europe. We had it globally protected. Chrysler Globe somehow lost the contract with Chrysler, and Chrysler sent me to another supplier, Ryder Schaffnacher. We failed to get an agreement with them. They proceeded in manufacturing, and thus the patent infringement suit. The patent infringement suit was conducted by a law firm of Summers, Schwartz, Silver and Schwartz. It was pretty straightforward. In fact, we were ahead in the suit. We had won the Markman hearing, the pre-trial of it, and somehow we ended up losing in summary judgment. At this point, I needed to figure out what happened, what went wrong. Usually when a person wins the Markman hearing, they usually prevail in summary judgment. They prevail in the case and they're usually able to settle the case. But that wasn't the case with me. So I went back to the source, which was Dr. Kenneth Cohn. He's the foremost expert in this region, in this area, and he actually wrote the patent for me. I talked it over with him. We looked at it and we both determined that this was something that could have been won. So I'm going to bring in Dr. Cohn and get his feedback, and I'll be back with you shortly.
I am Dr. Kenneth Cohn. I'm an intellectual property attorney, patent attorney. Keith Taylor came to me 20-some years ago with an invention that consisted of a mirror assembly that had a translucent housing and a mirror disposed in it, and inside the translucent housing was a light projector. And this device during the day looked like any mirror assembly, but at night when the light inside the assembly was turned on, it could project an image through the housing at a very elegant appearance. And Keith actually came in with a professionally made prototype, and that prototype had a Chrysler Pentastar that was projected. It was a beautiful assembly. We realized that there was a good deal of patentable technology in the assembly, and in analyzing it, we also realized that during this period, the high-mounted rear stoplight was being required in cars, and we realized that this assembly could actually, besides functioning as an ornamental device could also be the means to create a front-mounted stoplight or turn signal. So when we drafted Keith's patent application that eventually issued into a patent, we covered these aspects of the invention. I lost contact with Keith for a period of time, and also left my old law firm of Rising, Ethington, Parnard, Perry & Milton. Started my own firm, Cohn & Associates. And Keith, when it came time that there was going to be litigation, didn't realize that I had moved. My old firm told them that they didn't know where I was, which was another issue. And so Keith ended up going to Summer Schwartz. Prior to that, during the prosecution process of Keith's patent, Keith entered into an agreement with Scheller Globe, which we helped him negotiate, we drafted. Keith ended up getting 2 upfront payments from Scheller Globe, and then, as Keith said in his first introductory segment, Scheller Globe ended the agreement. And then over time, Keith then saw, and actually I also saw, that there was Mercedes-Benz cars with high-mounted turn signals in their mirror assemblies, and we realized that was I realized on my own that was Keith's invention. But at that point, Keith and I were out of communication. Eventually, I received a phone call from the judge's office who was handling Keith's lawsuit with Mercedes, Daimler, Chrysler, and the Tier 1 that they were using to actually manufacture the mirror assembly. And the judge's office called me to tell me that there seemed to be a lot of confusion on both sides of the attorneys in the case, and that I maybe should contact Keith. They knew that I was involved because my name was on the face of the issued patent. I then became in communication with Keith again. I ended up getting deposed by opposing counsel with regard to some minor issues that ended up getting resolved and not being issues in the lawsuit. But at that point, Keith had already started using the Summer Schwartz attorney and stayed with the Summer Schwartz attorney. In the end, there was a summary judgment motion in which the judge actually took over the analysis of the patents from the attorneys because the judge clearly didn't think the attorneys presented either attorney presented much of a persuasive argument, and then ended up ruling against Keith. Since then, I've been assisting Keith in trying to get some resolution of this matter because, as Keith said in his introduction, his assembly has turned up in about 40 models of cars, and Keith never received any further compensation for this. One of the other peculiar things that happened during the lawsuit was that, and Keith told me about this, so I've got this from Keith, that during an early motion, his attorney ended up dismissing the Tier 1 manufacturer who was clearly an infringer. So there was a lot of peculiarities about this lawsuit. I know that Keith went to counsel with regard to malpractice issues. I'm sure Keith will talk more about that in his next segment, and never ended up getting compensated. We've been through television interviews, we've met with the NAACP about various issues, but Keith sadly and arguably unjustly was the inventor of this technology, ended up getting it patented. We patented it for him, and based on various lack of expertise, has just never been compensated.
So, you've heard from Dr. Cohn, And we're up to the point where we're now faced with a malpractice case. Summers Schwartz was a hard firm to sue because they had conflicts of interest with almost everyone I ever talked to. Someone had some type of conflict of interest with them. So I found an attorney by the name of Tony Braun. His name is Richard L. Tony Braun with the Benner & Benner law firm. I asked him, do you have a conflict of interest with Summers Schwartz, Daimler, Chrysler, Ryder Chefnacher, or Benaik and Pine? And they said no conflict of interest. We met several times before Mr. Braun revealed to me that he formerly worked for Summers Schwartz, but at the time it was Summers Schwartz, Silver, and Taylor, and that it would be no problem, he had no conflict of interest. He then brought me to E. Powell Miller of Miller Law. Asked him the same question, do you have any conflicts of interest with any of these groups? He said, no, we have no conflict. I can represent you fully. When Miller took the case, he brought in attorney David Shea. David Shea just happened to be working at Summers Schwartz at the time that they were representing me. I asked him, is there any conflict of interest? He said no. We have this lawsuit going with an attorney suing his former firm, and I was uncomfortable about it. I called Mr. Braun back again. He urges me to go ahead and proceed with them. They know what they're doing. In the meantime, we went to Ann Arbor for a federal, the case began at federal court in Ann Arbor. 3 days prior to the court meeting, the court date, my home was vandalized. Saturday morning, 3:35, 4 o'clock. Someone came in and threw stones through my windows, broke all of my windows. 3 days before I had to appear at federal court. Made a police report, told my attorneys, David Shea and Lauren Northrop, what happened. They said, I can't tell this to the court because the judge will throw my case out if I mention this in court. So I went ahead, following their instructions. We went on, they sent the case downtown to Judge Drain. Judge Drain dismissed the case, and they appealed, and the case was dismissed. I didn't find out till after the case was dismissed that Tony Braun also worked for Daimler and Chrysler and never told me. I asked him several times. He denied it each time. Someone connected with Chrysler had influence on this case from before the patent was pending all the way through the malpractice process. That's conflict of interest in my opinion. So from that point, I had to now find somebody to sue them. Even harder to do. But because of this experience, I didn't trust anybody else, so I filed a multi-billion-dollar lawsuit myself in federal court. So I filed a lawsuit myself in federal court. In the meantime, I did a Fox interview with Fox 2 News. I made 2 videos. The second video that I made, I began to name names of participants. 3 days after that video was made, I began to experience home invasions. I had a series of home invasions 3 days after the videos hit the air. Now the strange thing about this is, people break in and they steal computers and stuff that they can pawn or what have you, tools. But these people also stole all the documentation that went along with the cases. And I wonder who would ever do that? Why would anybody ever do that? At this time, I didn't even know that Tony Braun had represented Chrysler. I found it out on the internet. Looking up other cases, I found out that he worked for Daimler Chrysler is on their webpage of E. Powell Miller. So again, I go back and I sue now. At this point, I bring lawsuit against Fiat Chrysler and Daimler AG. I launched a multi-billion-dollar lawsuit against those companies and 15 other participants. The charges included 8 counts of fraud and conspiracy to commit fraud, collusion, obstruction of justice, racketeering, and running a criminal enterprise, fraud upon the courts, federal, state, and appeal courts. Although the federal court accepted the allegations of Taylor, a pro se applicant, Taylor cannot bring a criminal case, and the case had to be dismissed. The only group that can bring a criminal case is the Attorney Grievance Commission, the prosecutor, or the Attorney General. So I went to the Grievance Commission again. Annie Ruth Stevens took the case. As I said before, maybe you should recuse yourself from this case. She said she could be fair and open-minded about it. She redefined the charges so they had no bite to them and dismissed the case, claiming that I'm only angry because I lost. It's my opinion that there is some collusion also with the Attorney Grievance Commission, and I'll give you examples of why I say that. Attorney E. Powell Miller has been on the ethics board for the state bar. They tell the other attorneys how they should behave. He was a participant in this case. Attorney Stephen Wallach was a defense attorney, and he's on the attorney discipline board for the state bar. He was a participant in this case, which was named. Attorney Brian Einhorn was a defense attorney, and he actually became the president of the Bar Association. So I had these concerns, and I was asking that the Grievance Commission recuse themselves from the case and turn it over to the prosecutors, the State Attorney General, or the Justice Department. They did neither, and they voted off as I'm just angry that I lost. In the end, Tony Braun worked for Summers Schwartz, and he also worked for Daimler Chrysler, 2 of the participants that I sued. And the end result was I didn't get a settlement or a victorious lawsuit. It's my opinion that this case was railroaded once I was intercepted by Mr. Braun. This case was railroaded, drove right into a wall, and crashed. I was never going to prevail with this set of attorneys. They all had ties for some reason with Chrysler or with Summers Schwartz. We think these kind of things don't happen, but they do. In fact, Chrysler, an executive from Fiat Chrysler, just pled guilty of fraud in the UAW. Fiat Chrysler also just paid $650 million to the feds for committing fraud on the government. While all these things were transpiring, Chrysler had the nerve to be taking government money as a bailout. They wouldn't even be around had they been prosecuted. Dr. Cohn and I will be back for some last words in this matter. I would hate to see people be incarcerated behind this. The allegations here add up to 140 years of incarceration for all the participants involved in this, if this case is true. I would like to work out a settlement with Daimler and Chrysler. They are welcome to come and talk to either me or Dr. Cohn. We had an open invitation before for all the participants. The only one that showed up was David Shea. Out of all 17 participants, he's the only one that showed up. We extend the offer again to come and meet with us and any other mirror manufacturers that would like to come and talk with us about this matter. we'd be glad to have you in conference. In the end, no one is above the law. Not a person, not a corporation. Also, in the end, everyone has a right to unencumbered representation. At the end of this, it shouldn't be a big question mark. There should be a period or maybe even an exclamation point. But there shouldn't be questions of conflict of interest. Those type of things don't belong in our society. This affects everyone listening. Everyone needs to be able to hire an attorney that is not encumbered or not mixed up in the other party's business. Everyone needs to be able to hire an attorney that has no conflicts, that they can trust to tell them anything and bring the cases fairly and honestly. I'm here with Dr. Cohn. You know how to reach us. Thank you everyone for listening.